Today's webinar is about understanding the differences between security clearances, public trust, and suitability determinations, kind of discussing what each one of those are and why it's important and how it can have an impact on various different types of employment. So as Brittany indicated, my name is Ryan Nerney. I'm the managing partner in the California office of Tully Rinke. And just a little disclaimer before we get started, this webinar is not intended to be legal advice. The views expressed in this publication are mine and do not imply any endorsement by any government agency, including the Office of Director of National Intelligence, the intelligence community, or any other government agency. So as Brittany indicated, I'm going to go over kind of what each one of these aspects are. What is a security clearance? What is a public trust? And suitability. Sometimes those go hand in hand, sometimes they don't. And what are the key differences between them? Some are applicable to both federal employees, military members, and government contractors. Others are not. And it also depends on the government agency that you work for, or as a contractor that is your client, as far as like the suitability determinations go. So first, going to suitability, primarily suitability determinations are governed by 5 CFR 731.05. It applies to competitive service, career SES applicants, and employees, essentially federal employees. Sometimes in these circumstances, there's the ability to appeal any adverse determinations to the Merit Systems Protection Board, MSPB. It kind of depends on the circumstances. The purpose of this is not necessarily to go into the whole aspects of appeal rights for suitability, but kind of just provide a general overview of that. But again, in some cases, MSPB is an opportunity for appeals if a suitability determination is negative or unfavorable. There's a similar process for government contractors. Sometimes it's called credentialing, which requires physical access to federal facilities. It's different in a sense to actual suitability determinations because essentially suitability determinations are a determination for suitability for federal employment. So obviously, as a government contractor, you're not working directly for the federal government. You're assisting on projects, as a contractor, but not for the actual federal government. So suitability determination isn't the proper term for that. It's really more like credentialing or those types of things, but they are similar as far as what's looked at. But essentially, it goes to the concerns based upon an individual's character or conduct that may have an impact on the integrity or efficiency of the service. So essentially, I mean, there's various different aspects that could kind of trigger at least a review of a suitability determination. Excuse me, not necessarily an unfavorable decision, but it could be a review of potential concerns. And there's several issues on the security clearance eligibility that can also be disqualifying for suitability determinations. So again, it kind of goes hand in hand. I'll get into it kind of at the end of this presentation, but it goes hand in hand because sometimes it's a backdoor way for agencies to kind of not have to go through the whole adjudication process for security clearances. And for suitability, this is done prior to the clearance adjudication in most cases. I have seen it in some cases where individuals who obviously already have a security clearance, maybe they get a job with the federal government, and then they still have to go kind of through the pre-screen, for suitability for a federal job. So that would be kind of an exception. But if you don't have a clearance and you're trying to get a job with the federal government, they typically go through the suitability aspect first. Sometimes it's in conjunction, at the same time as one another. But for the most part, that's kind of where these suitability determinations happen. Moving on to security clearances. Security clearances, this is more of like the general thing. A lot of people probably understand what this is. It's a separate adjudication. So just because you're found suitable for federal employment doesn't necessarily mean that you'll be able to be granted a security clearance, because you're governed under different guidelines and laws and adjudications. or policies, I should say. But the security clearance applies to both federal employees and contractors that require security clearance or access to classified material. You see on the slide it says requires a sponsor, so you can't just get a security clearance. You need to have an actual sponsor, which is either a government contractor, an agency, a government agency, a subcontractor even. One of those has to sponsor you for a clearance, essentially telling the government that this person requires a security clearance, in order to do their job. Without an actual sponsor for your clearance, you cannot get a security clearance. The security clearances are governed under various different things, but it primarily stems from Executive Orders 10865 and 12968. Those are essentially the guidance where all the other, the SEAD 4, which I'll talk about in a second, the Intelligence Community Policy Guidance Directive, any of those types of things that kind of hold, adjudicative guidelines or policies for security clearances, it all comes from those executive orders. Some other laws as well, but for the most part, it's those executive orders. For a security clearance, unlike a pre-screen, which is, for suitability, a pre-screen usually entails, an OF 306, maybe a couple other forms, in order to get a security clearance, which goes from anywhere from like the confidential level all the way up to a top secret SCI, full scope poly, essentially the highest clearance you can get. All starts with an SF86, which is a standard form 86. It used to be called an EQIP, or the platform, I should say, was EQIP, that used to fill out. Now it's EAP. It's constantly changing on where you fill these applications out, but essentially it's an application that goes through all aspects of your life, all aspects of your background, that is submitted to the government in order to determine your eligibility for a security clearance. At any level at this point now, if you submit an SF86, that is followed by an interview from an investigator. A lot of times, if you're talking about the Department of Defense, the interviews are from like DCSA, Defense Counterintelligence and Security Agency, people or investigators. But the interviews really are primarily based upon what you submitted with your SF86. They'll do a financial check, a criminal background check, and those types of things as well. But the SF86 is really the start of providing the information that is needed in order to adjudicate your security clearance, again, to determine the eligibility. There's various different sections of that form that goes anywhere from the past 7 years to the past 10 years to ever in your entire life if you did something. So it's a very comprehensive application, far more comprehensive than the suitability forms that you would have to fill out. And sometimes even the SF86 can provide information for suitability determination as well. So those kind of go hand in hand as well. Security clearance adjudications are guided by 13 adjudicative guidelines, A through M. And those 13 adjudicative guidelines are held within what they call the Security Executive Agent Directive 4, which is the SEAD 4. And those lay out both the adjudicative, the 13 adjudicative guidelines, which all have the disqualifying conditions and mitigating conditions. And those are essentially the guidance on what any adjudicator for any government agency looks at in order to determine if somebody should have a security clearance or not. So the adjudication, as you see here, establishes a reasonable expectation that the person's appointment or eligibility for access to classified information would or would not be clearly consistent with the interests of the national security. Essentially, any adjudication, if there's any question of potential issues, they usually err on the side of national security. But that's kind of in general what they look for when they're adjudicating these security clearances. And then as far as an appeal, if there is an unfavorable determination for a security clearance, it's usually notified via various different documents. It depends on the agency. If it's, the Department of Energy, it's a summary of security concerns. Various other agencies typically call it a statement of reasons or a letter of intent to deny or revoke your security clearance. But the common phrase that is typically used everywhere is a statement of reasons, or SOR. And that basically lays out what the specific concerns are. And typically you're provided an opportunity to submit a written response and or a hearing or personal appearance, again, depending on the agency that's sponsoring your clearance. The Department of Energy is typically one or the other. Other agencies, such as like the DoD, provide a pathway for a written response first, and then a hearing or a personal appearance. And that's even different depending on if you're a contractor or a federal employee, which I believe we've done a webinar on before. If you have any questions about that, but ultimately, if there is an unfavorable determination after adjudication for security clearance, you're typically provided an opportunity to respond to what those concerns are. The next aspect is a public trust. This also requires a sponsor for a public trust, as you would for a security clearance. You do have to fill out something similar to an SF-86, but it's not as intense. So there's various different levels of public trust. There's a non-sensitive, and then there's a public trust or a high-level public trust. If it's non-sensitive, you have to fill out just an SF-85. Only goes back maybe 5 years of your life, not as intense. SF-85P is more intense, so I would call it a step under an SF-86. A lot of the information is the same as you would put in SF-86, but again, not as intense. Maybe in some sections you don't have to go back as far, so it's not as high of a level of a security clearance. It's typically for individuals who are working in a position of trust, is what they typically call it. So again, a step below security clearance eligibility. And a clearance denial or revocation doesn't outright mean you will be denied a position of trust or a public trust. It will have an impact, a significant impact, I would actually say. But just because you're denied a clearance doesn't necessarily mean that you wouldn't be able to get a public trust. I will say that if you are denied a clearance, let's say for the Department of Defense, and you're trying to get a public trust for the Department of Defense, probably be a little bit more difficult. If you go to maybe a different agency, it may not be as difficult for that. But it's important to understand that a public trust is not a clearance per se. It can be granted based upon simple criminal or credit checks. So again, it's easier to obtain than security clearances, common for positions of trust like IT, finance, those types of things, that, you may have to be using or, gaining access to some PII or something like that, so maybe sensitive information, but it's not classified, or there's no real risk of you running into classified material. For public trust, there's offers for appeal options. For the DoD, depending on the circumstances, if it's a high-level public trust, they call those ADP cases. And it follows a very similar process to the security clearance, but there's just kind of different guidelines, I would say, as far as if somebody should or could be eligible for a public trust. But if it is one of those options, then you do potentially have an opportunity for a written response and even a hearing, if you're denied a public trust. But again, it depends on the agency. It depends on the circumstances. It even depends as far down as the position that you're even trying to get. So there's a lot of similarities and differences, I would say, for each one of these. So there's an application that always starts for public trust and security clearances, as I mentioned before. It's all through the EAP system now. It used to be EQIP, but now it's EAP. Clearances utilize the SF-86. Public trusts or lower level non-sensitive positions start with an SF-85 or SF-85P. Typically, I'm seeing now is that any SF-86 that's filled out, or even SF-85 or SF-85P, does require a personal subject interview. So essentially an interview with an investigator to kind of go over all the information that you put in the application, and to determine essentially if you should have the eligibility of whatever level you're seeking, again, whether that's clearance or a public trust. The regulations are also different. So again, you have the SEED 4 for the security clearances, and then the suitability is 5 CFR 731. There's also some guidance with the Office of Personnel Management, OPM, that provides some more information as it relates to suitability determinations. Um, and then the adjudication process. So talking specifically about clearances, like I said, you have the opportunity for a written response for a hearing most of the time. I would say actually all the time. And an opportunity for a hearing depends on the agency if you're provided with both of those opportunities. As I mentioned before, Department of Energy is one or the other. While you can submit, I guess, a mini written response just with your notice of intent to appeal, or have a hearing, I should say. Most of the time, you can't do a comprehensive response because then you waive your right to a hearing. So it's important to kind of understand and read all of the documentation that you receive, whether it's even at the application stage all the way down to the adjudication process. As I said before, for the most part, suitability is first, and that could be credentialing, like I said, for contractors, or it could be a suitability form. Like I said, usually they get that information through an OF 306, something like that for federal employees. And then they kind of go through the whole process of, a public trust or a clearance adjudication. If you already have a clearance, then that doesn't mean that you're 100% in the clear for suitability. And also it depends on how long you've been out of a job, right? If you're going straight from job to job, there probably won't be any lapse. But if you've been out of the workforce for a little bit of time, then even though if you still potentially have eligibility for a clearance, you could be required to fill out an SF-86, and obviously would be required to fill out any additional onboarding paperwork. Like I said before, like the OF-306 and those types of things. I briefly mentioned this, but a lot of times the agencies use the suitability aspect as a backdoor way for an agency to pre-screen to see if you would be eligible for security clearance. So even though they're different regulations, a lot of times it goes to the same type of characteristics that they look for suitability and security clearances. So for instance, if you're going to have a problem being found suitable for federal employment, then that kind of tips off the agencies that you're probably going to have some issues with getting a clearance. And then at that point, they could just pull the job offer. If they go through the whole process of, you've already been onboarded and you've already started and those types of things, obviously you're typically subject to a probationary period, but it still makes it a little bit more difficult to kind of get rid of somebody if they're doing that. So if they can't get the clearance, and it also is a long drawn out process usually. So as I said before, agencies sometimes use the suitability process as a means to kind of pre-screen if somebody would be eligible for a clearance. If they're not, then like I said before, they may pull that job offer. So those are kind of the similarities and differences. There's a lot of overlap here, and it kind of depends on your particular position, what you're trying to do, the type of information that you'll be handling in that particular position, as far as, if you're going to be subject to a public trust or, security clearance or suitability. A lot of government contractors don't necessarily do the whole suitability aspect or credentialing. They kind of have their own internal process and kind of rely on the security clearance and public trust process to kind of vet, if they need to. But for the most part, that's kind of the similarities and differences between these aspects. So I know some of you submitted some questions before. So one of the questions I got was, has there been anything that's changed with the new administration processing scrutiny? I wouldn't say the overall like aspects and adjudication has changed, but and this is with honestly any new administration. Different administrations kind of focus on different aspects, right? So it's all under the same regulations, the CED 405, CFR 731. But you heard me mention those adjudicative guidelines before. Maybe the previous administration would focus more on I don't know, guideline E for personal conduct. And this administration may focus a little bit more on, guideline B for foreign influence or something like that. So it's all within the adjudication process, but there could be a little bit more emphasis on various different adjudicative guidelines, at least when it comes to security clearances. See, another one was, can you have a security clearance for a government contract? I mean, yes, obviously, if you work for a government contractor and your position requires you to work on a classified project or even potentially come into contact with classified information, that is something that potentially, could lead you to getting a security clearance. Ultimately, the answer to that question would be yes. I've been at an interim level for a while. Is that an unusually long time? So as far as it comes to interim clearances go, interim clearances are typically submitted by an employer, so somebody can kind of just get started immediately if they don't already have a security clearance. Those are usually either granted or not granted based upon the preliminary information that is submitted. So if you submit an SF-86 or an SF-85P or something like that, to grant an interim, whether it's typically a security clearance, sometimes public trust, but to grant an interim security clearance, they look at that general information. And if you're denied an interim clearance, that doesn't necessarily mean that you're denied a full clearance. But there's no appeal options for an interim denial. So if you're denied an interim clearance, it's essentially, sorry, Charlie, that's it. But that doesn't mean that you won't be able to get a full clearance, at that point. That's the majority of the questions that I have. If there's no other questions, I think we can go ahead and end this. So I just want to thank everybody for, oh, just got one more question. Let me see. If your clearance is denied, you get notice. Yes, with I guess one exception I'll say, you heard me say kind of the backdoor aspect of suitability. So for instance, if your job offer is pulled and you lose sponsorship for your clearance, that could cause what they call a loss of jurisdiction, or even before then. So in that circumstance, you probably wouldn't get notice. But as long as you maintain your sponsorship and you kind of you have that process, then essentially, yes, you would be getting some sort of notice, as it's required from the regulations. Other than that, I think that's pretty much it. We'll go ahead and end this now. I appreciate everybody taking the time to attend today. And I know Brittany will let you know, but you should get a copy of these slides, or excuse me, a copy of the presentation should be forwarded out. So thank you so much for attending. I appreciate it.